My name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and we always are producing more and more videos designed to educate our viewing audience. And today, we're going to talk about what it means to have a divorce settlement. Please subscribe to our channel. You know, you have a divorce case, you're fighting, you're going back to court. Every, motion day, there's another motion, there's another argument, there's more this, there's more that. You're paying lawyers, you're fighting about homes and businesses and dividing up assets and liabilities. Ultimately, at the end of it, there's going to be a settlement. It's going to be a settlement that the parties reach their own choice. It's going to be a settlement that the parties reach because the attorneys help them out. It may be a judgment that the court arrives at because the parties couldn't settle the case. But at one point in time, the matter is going to be subject to a settlement agreement or a judgment. What does that really mean? Well, it means a few things. The general proposition is that it means that it's over. There won't be any going back after the court signs the judgment to say, I want more of the house. I want to give less of the 401k. I want to do this, I don't want to do that. There's no buyer's remorse with respect to the settlement. When the court enters an order consistent with the settlement or enters a judgment based on a trial, the property case and all the issues regarding the property that you had in the marriage, it's over. It's not really going to be something that you can complain about. You're not going to be able to come in and say, I'm having second thoughts on it. There are certain things in a judgment that are just etched in stone. There are certain things that are always subject to revisiting. Custody, parenting time, child support. Those are things that can be revisited. But who's getting the couch? Who's getting the new car? Who's getting the old car? Once you agree on that or have the judge make a ruling on that, it's pretty much going to be over. Don't expect that you'll be able to go back on the settlement and change your mind. Therefore, pulling an appeal out of this equation, if you're going to settle your case, if you're going to go and approach it, understand that that's going to bring an end to that case, and it's going to create a scenario where you can't go back. If the court let people go back, then there would never be finality, because the court would enter judgment with the understanding that, somebody's going to come back and revisit it and complain and change it. The court's not about that. If you want to go back and forth and negotiate it, you can do that before the court has a trial and makes a judgment, or before you put a settlement on the record, because once either of those two occur, it's damn near unlikely that it is ever going to be changed. So you need to be aware of that going in. Now, if there's some sort of error of law, some sort of irregularity that occurred, of course, that's what the Court of Appeals is for, to correct that, and that could be the difference. But the general proposition is exactly as we've just outlined. Now, if you have any questions about that, reach out and we'll be glad to help you out.